This video is a professional legal analysis of self-defense situations. This content is for educational purposes. We discourage the imitation of dangerous activities.
Do you know the 3 most dangerous words that can destroy your self-defense case? Learn what they are on Freedom on Trial. Hey everybody, I'm Howard Snader, and I'm a senior criminal defense attorney for the Attorneys for Freedom law firm. Take a deep breath and say, I did it. Say with clear intent and strong belief the 3 most dangerous words in self-defense law. I did it. How does admitting to a felony feel? That admission is enough to get you investigated, arrested, and prosecuted. Here's one of the strangest things about self-defense law. In most self-defense cases, you must admit that you did it. It sounds backwards, doesn't it? There are many common defenses when you are accused of a crime. Some of the more common defenses you already know. I didn't do it. This is a mistake of fact. You're denying any wrongful conduct. It wasn't me. This is mistaken identity. I wasn't there. That's an alibi. And then you have self-defense. Self-defense is a different creature. Self-defense is an affirmative defense. In most courts, you need to affirmatively tell the prosecutor, the court, and the jury that you committed the underlying crime. Think about that. You need to admit that you pushed the person, that you shot the person, that you performed some conduct against another person. Then you get to say that although you committed the underlying action, you were legally justified in doing so because you were facing an imminent threat of serious physical injury or death. When you argue self-defense, the question is no longer, did you do it? The question becomes, why did you do it? Were you facing an imminent threat? Was your fear reasonable? Was the force proportional? Did you become the aggressor? Had the threat ended at the time you acted? That's your battlefield now. And this is why self-defense cases are so dangerous, because you are admitting conduct that would normally be a felony. Again, think about that. You're standing in court saying, yes, I threatened, injured, or killed another human being. You needed to convince 12 strangers to agree that you did cause the harm alleged, but you had no reasonable alternative. Normally, you don't need to prove innocence, but with an affirmative defense, it will be for you to present your self-defense argument and convince the jury that you acted legally. People think self-defense is automatic, like yelling self-defense is some kind of magical force field that protects you from being prosecuted. Nope. At Attorneys for Freedom and Attorneys on Retainer, we teach people that self-defense is not an excuse people simply accept. It is a legal argument supported by evidence, witness testimony, forensics, timing, behavior, and credibility. Everything matters. Your statements, your actions, your training, the video, the scene, even your behavior after the incident. Once you admit the act, the courtroom becomes a battle over one question. Were you protecting life or taking it unnecessarily? With self-defense, you're not saying I'm innocent, you're saying you're justified. Self-defense cases are not about denying violence, they are simply justifying survival. Thank you for taking the time to view our content. If you'd like to learn more about our self-defense program and what it can do for you, please go and check out attorneysonretainer.us. This is Attorney Howard Snader signing out. Be safe.